Welcome to the Supreme Court of the United Kingdom, where today we are beginning the hearing in the case of BTI 2014 LLC and Sequana. This is a case concerned with company law and in particular the duties of directors in relation to situations where companies have debts. I'm hearing the appeal with four colleagues whom I'll introduce now. First, the Deputy President, Lord Hodge.
Good morning.
Lord Briggs.
Good morning.
Lady Arden. And Lord Kitchen.
Good morning.
The appellant, BTI, are represented by Mr. Andrew Thompson, Queen's Counsel, and Mr. Kieran Keller. And I'll invite Mr. Thompson now to begin his submission. You're muted, Mr. Thompson.
Am I now unmuted?
Yes.
I apologise. Well, my lords, my lady, I'd like to start, if I may, with just a few general observations. The first is that it's very interesting that the respondents refer in their opening remarks in their written case to the case of Salomon, which, of course, as we all know, is the case that famously affirmed and cemented the principle of separate corporate personality. So that's the separation between the company as an entity and its members. And yet we will suggest that the respondents' submissions often end up seeking to quietly undermine or ignore the effects of that very basic principle. Now, Salomon was perhaps the first modern company law case in a sense. If I may, I'll just refer to what the late Professor Seeley said about it in the 1987 article that is in the authorities bundle. It is at page 4730. Until Salomon, Professor Seeley pointed out, in the Victorian lawyer's eyes, the company was regarded as the associated members rather than the legal entity. The company was they and not it. And one can, of course, see that in some of the judgments in the lower courts in Salomon itself. And Professor Seeley then goes on to observe on the same page, highly pertinently for this case, that much of the law handed down to us reflects this Victorian perception of the company. In particular, for present purposes, and pausing there, that was, of course, a focus in that article on directors' duties. The idea of the director as trustee or agent for his or her constituents, the company in the sense of the collective corporate membership. Now, Professor Seeley made that observation in the context of his opening remarks in that article on the page before, 4729, where he said in the fourth line, and this is still very much pertinent for today, it slowly becomes apparent that the ancient rules and concepts, which may have served their purpose well enough when the companies in the 1880s brought their disputes before the courts of the 1880s, can no longer cope satisfactorily, even with the same problems a century further on. And of course, many of the problems are new too. Now, those comments by Professor Seeley were, of course, made in 1987. But the words are prescient, like much of the rest of the article. And of course, as regards the question of the role of creditors' interests in formulating directors' fiduciary duties, the following 36 years have been rather significant. In particular, of course, we've got the development by the courts of directors' fiduciary duties to encompass creditors' interests and the codification of directors' duties in the 2006 Act. And this is, of course, the first occasion on which that development has come before this court. Now, the respondents will no doubt resist this characterization very strongly. But we say that the reality is that what they're inviting the court to do is to reverse entirely the judicial developments, directors' duties in this way over the last 36 years. And in so doing, actually return English company law to a more Victorian conception of the relationship between the company as an entity and its members and its creditors, in a manner which is not only inconsistent with those recent judicial developments, but also inconsistent with the approach in the 2006 Act. All of which recent developments are entirely in keeping with the role of companies in the 21st century in commerce and in society more generally. Now, with that preamble, of course, there are lots of points that we need to get to, and I'm keen to get to them, but can I just now make a number of general observations which will keep cropping up, or at least their relevance will keep recurring during the course of submissions. The first is that, of course, separate corporate personality is absolutely central to the purpose of companies. It's not an accident. It's a separation between the company, its investors, with the company holding the assets and taking on the liabilities, not only allows limited liability, but also a perpetual enterprise, which otherwise isn't possible. And of course, facilitates the split between investment and management. And directors inherently have a critical role, of course, as well. Companies have to have directors, and invariably they are primarily responsible for managing the company's affairs, which is an implicit assumption of the 2006 Act. And therefore, it's they that owe fiduciary duties to the company as an entity. And it's absolutely critical that the duties that we are concerned with today are duties owed to the company. On breach, the company has the cause of action, and occasionally the respondent submissions lapse into referring to duties owed to creditors. And one sees in some of the early authorities a similar lapse, but that is not what this case is about. It's perfectly possible for duties to be owed, in theory, directly from directors to creditors on a bespoke basis in unusual circumstances. But that is not the focus of today's debate. That is, the focus of today's debate is duties that are owed to the company as codified in particular under Section 172 of the Companies Act. However, if I may, I will refer to the creditor duty, just a shorthand, not because that's referring to any duty owed to creditors, but simply to make life easier. I should be clear, what I'm actually going to be referring to there is not any sort of separate duty, but actually to the modification of the Section 172 duty as permitted by Section 172, subsection 3, to allow a creditor's interest to be taken into account. So it's not strictly a separate duty at all, but merely a modification of the general Section 172 duty. Now, it's long been recognised, even before the 2006 Act, that behind the corporate entity there are, of course, other interests, primarily, historically, those of different groups of shareholders. But since the 1980s, it's increasingly been recognised that there are other constituencies of interest, in particular the creditors. And we'll see that that's actually at the heart of Section 172, which requires the directors to at least take into account a variety of other constituencies of interest. But here we're focusing, of course, on the two main constituencies of interest, the members and the creditors. And of course, they have different rights in relation to the company, and therefore different interests. And those rights are going to vary necessarily from case to case, depending on the terms of the articles, and in the case of the creditors, on the terms on which the creditors advance. But we've got to make some generalizations. If I may, I'll just identify the collective interests, and I emphasize collective, that arise in relation to members, I should say really effectively shareholders here, and creditors. The members, the shareholders collectively, will have the right to appoint and remove directors. Depending on the precise terms of the articles, they'll have the right to receive dividends if any are paid, and they'll have the right to the distribution of the residual assets on a solvent winding up. And that's what justifies what we see in section 172 subsection 1, making the primary duty of the directors to promote the success of the company as an entity for the benefit of members. On the other hand, the creditors individually will have various rights, but collectively they have a class remedy of winding up and now also administration. And in an insolvent winding up, they will, of course, have a pari passu entitlement to the proceeds of realization of the company's assets. And it's that collective interest which we'll see is why the courts have identified a need for directors to take into account the interests of creditors in certain circumstances when discharging their duties to the company. Now, by contrast, the respondents contend that the members always have a superior interest, so that their interests will always be the exclusive focus of the directors, even in a situation of actual insolvency. They also say that it's members who can always ratify decisions by directors, because on their case, the respondent's case, the members are the company. They are, to use their phrase, the corporators. Now, we say that would be a most remarkable outcome, not only entirely contrary to a large number of judicial decisions here in Australia and in New Zealand, but also without any support from any recent authority, and effectively a reversion to a Victorian conception of the company. Because specifically, the respondents are effectively inviting the court to dilute or even ignore the separate corporate personality of the company by regarding members as, in substance, the company, even if it becomes deeply insolvent. And that's why the reference to Salomon is perhaps apt. Now, we say also the respondent's argument is entirely inconsistent with the modern approach to companies as embodied in the Companies Act 2006, which expressly recognises the corporation as a separate entity, a separate enterprise, with a range of different interests behind it. So in fact, this appeal is, to some extent, although on the face of it about creditors, also about the relationship between the company and its members. Not only are members not the company, they're also not, strictly speaking, owners of the company, at least not in the same way that we would own a chattel, for example. They don't own the separate corporate legal entity. Rather, they've got rights in relation to that entity, against it, against other members, against directors, all bundled up in a share. And it's the share which the members own, rather than the company. Talking about members owning the company is, in everyday terms, a perfectly good metaphor or colloquialism, but not, strictly speaking, legally accurate. So the members collectively are neither the company nor the owners of the company, but merely the most significant stakeholders in it. And so the issues on this appeal are broadly in relation to directors' duties, specifically what limitations on members' rights and interests are there for the protection of creditors arising prior to liquidation or administration. In the respondent's case is that at common law, there are basically no restrictions on shareholders' control of the company and on the director's obligation to pursue the shareholders' interest exclusively, except common law rules on maintenance of capital, because they say the director's duties are never modified and shareholders can always ratify. So the only restrictions on the respondent's case are effectively statutory. On our case, the restrictions are not so limited. As regards the director's duties encompass shareholders as creditors' interests, creditors' interests prior to liquidation or administration while the directors are in control, and even if the company does not ultimately go into liquidation administration. Now, I should say that such restrictions are, we say, part and parcel of company law, because companies are, of course, statutory creatures. They owe their existence to legislation, and the legislation therefore controls, with the common law, the terms on which companies are available as vehicles for enterprise. So legislation has created a specific legal vehicle because it provides advantages to commerce and society generally, but only on the basis of certain rules and conditions, because its availability is for the general benefit of society on those terms and on those terms only. So corporate status is not an unconditional entitlement. And those restrictions are not just limited to so-called abuses of corporate personality or limited liability, but they're much more general. They have now, of course, been codified, at least as regards directors' duties. These are part of the terms on which the legislature makes the company available, dealing with the basis on which decisions can be taken on its behalf. So, Lords and Ladies, those are my main opening points. I suppose the one other thing I should deal with is some points regarding the role of Parliament as opposed to this court, and policy, largely responding to points made in the respondents' written submissions. I mean, they have, and this is just for the court's reference at paragraph 12 of their written submissions, suggested that this is an extension of the law that we're seeking, and that's something that this court should leave to Parliament. And they repeat similar points at the end of their submissions under the note of caution heading. That's paragraphs 102 to 106. Now, our response to that is essentially this is a mischaracterization as an extension. The current law is not settled, obviously, but the creditor's duty is established, and it's simply its precise content and scope that is unclear. And Parliament has, of course, very clearly left this to the courts. It could not be more clear in section 172, subsection 3. Codified the director's duties generally, but very glaringly left the common law in place in this respect and left that for development by the courts. And that's recorded expressly, for example, in the explanatory notes. It's explanatory note 332. We probably don't need to look at it, but it's 768 in the bundle. Now, the respondents also say that they point out this court can't undertake a pre-legislative review in the way that, of course, Parliament could, but we do have the results of the pre-legislative process running up to the 2006 Act, which is what Parliament had. And a related point that's made, I should probably deal with now at the outset, is this is essentially in paragraph 107 of the respondent's written case. That they argue that it's not possible, as they put it, to create a duty on policy grounds. They say it's a matter of principle. Well, we would, with respect, endorse the comment made by the Court of Appeal. This is paragraph 201 of the Court of Appeal's judgment, page 213, that these questions are an amalgam of policy, precedent, principle, and pragmatism. The balance may well be different on different points, but it's fair to say that as regards the question of when the duty arises, what we've crudely described as the trigger question, which is the subject directly of our appeal, does involve a certain amount of policy. A line has to be drawn as to when directors must at least take into account creditors' interests, and where to draw it does involve a significant element of policy. But it's one that Parliament, as I say, has manifestly left to the courts. And so we make no apology for our repeated references to policy. We would suggest simply calling a spade a spade. And one aspect of policy is, of course, creditor protection. Now, that's often dealt with in legislation, but it's not exclusively a matter for legislation. And here again, Parliament has left this to the courts. What do we mean by creditor protection? Well, part of it is, of course, the mitigation of the effects of separate corporate personality, specifically the separation of the benefit of the enterprise and the liabilities. Benefit essentially going to the shareholders, the liabilities with the corporate entity. Now, that does conclude my opening comments. As regards the rest of the submissions, if I may, I'll just give the court a roadmap of the order in which I propose to deal with things in. First, if I may, I'll deal with the content of the duty, which I think was in the written submissions question 4. The reason for dealing with it first is that it is, at least to a large extent, common ground between the parties. And there's a certain logic to dealing with it first, I would suggest, simply because if one has to go on to decide where the duty arises, it's at least useful to have some thoughts as to what exactly the duty is. Then, second, I'll deal with the question raised by the respondents as to whether the duty exists at all, even in a situation of actual insolvency. That's question 1, really, on the written submissions. I'll then deal with the question of whether the duty exists, it arises only in a situation of actual insolvency, which is the second point raised by the respondents. And that's really the first part of question 3 in the written submissions. And then as a separate section, I'll deal with the question of if it arises pre-actual insolvency, at exactly what point does it arise? And that's essentially our appeal against the decision of the Court of Appeal. And the question perhaps is whether the Court of Appeal's probability test is correct, or our real risk test, or something in between. And then finally, I'll deal with the third of the points raised by the respondents, which is whether the creditor duty, assuming that it exists generally, is excluded from application to lawful distributions to shareholders, which I think is, strictly speaking, question 2 in the written submissions, but logically comes last. So if I may, I'll proceed on that basis and therefore deal first with the content of the duty. Now, the common ground here, as I understand it, is that it's common ground that on actual insolvency, the creditor's interests are paramount if the duty applies, overriding shareholder interests. But before that, before actual insolvency, the creditor's interests merely have to be taken into account. Now, I should make some brief expansion on that. As regards actual insolvency, and as regards this issue generally, the Court of Appeal didn't reach any concluded decision. The Court of Appeal decided it didn't have to decide this. But there was an expression of view at paragraph 222, which is page 218, where it was suggested that where the directors know or ought to know the company is presently and actually insolvent, it's hard to see that creditors' interests could be anything paramount. And we would endorse that. I mean, as regards authority, I'm not going to take the court through it in any detail at all, but there is no authority has really addressed the question directly of whether there should be a different content to the duty depending on the precise state of insolvency. We have some authorities at first instance suggesting that generally the duty should be one to give paramount importance to creditors' interests, and those, just for the court's note, we've set out in the footnote at page 73 of our written submissions. And the principle, the reason why paramount importance should be given to creditors in a position of actual insolvency is essentially that the quasi-proprietary rationale, as it's been referred to in the written cases, in the Kinsella case, applies in full. The creditor's interests should be treated as more important than shareholder interests in practice, because they're simply much more directly affected by the decisions of the directors, and indeed the shareholders' interest in the decisions of the directors is greatly limited. Now, moving on to the position short of actual insolvency, what we say here is that, by contrast, both creditors and shareholders' interests are affected by the decisions of the directors. So take a simple example. If the company's got a small surplus of assets over undisputed liabilities, and it's got a disputed claim against it which would render it insolvent, depending on the outcome of that disputed claim, either the creditors or the shareholders are going to be most directly affected by the decisions that, in the meantime, the directors take. It's not necessary to say that they are affected equally, but neither should in principle necessarily always take priority over the other. Now, there are first instance decisions which, again, on an entirely general basis, suggest that both shareholder and creditor interests should be taken into account without addressing the question of whether there should be a difference depending on the solvency of the company. And we've referred to those footnote 14 in our submissions, page 74. It's the MDA investment management case. Particular page reference is 2955. An ultra-frame particular reference to the page 3697. But in neither case was the detailed consideration nor any distinction, as I say, drawn between actual insolvency and short of actual insolvency. So it is essentially a question of principle, and the principle in our submission is clear on this. Now, the next question is how exactly you define the duty. So if that's right in principle, how does this fit with section 1721? Now, the details of this may not matter for the outcome of the present case, given that in this case the court found that the directors were positively ill-motivated towards the creditors. So it would be a breach on any formation. It matters more generally, of course. Now, it may be worth at this stage just reminding ourselves of section 172 itself. We'll find that at page 724. One 721, of course, identifies the primary duty. And it does so by requiring the director to act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. I'm just pausing there. We can see from that it's a subjective duty. It requires the director to pursue the course of action most likely to promote the success of the company, not just likely. And it is to promote the success of the company. So the company is a corporate entity. But importantly, for the benefit of its members as a whole. So where this duty applies without modification, the requirement is to pursue success of the entity, but with the underlying purpose of benefiting the members. Now, where the direct creditor's interests have to be brought into account and are paramount, then that, as we're clearly told by subsection 3, has to be modified so that the success of the company therefore necessarily must be pursued for the benefit of the creditors generally. Now, interestingly, the position we would suggest needs a little more consideration, where in the pre-actual insolvency situation, creditors' interests are only to be taken into account, so they're not paramount. Now, in that situation, both creditor and shareholders' interests need to be taken into account. Now, Section 172 doesn't spell out how that is to be done in the context of modifying the duty under subsection 1. But it clearly is to be a modification of subsection 1, because if we go over to subsection 3, we are told that the duty imposed by this section has effect subject to any enactment or rule of law requiring directors in certain circumstances to consider or act in the interest of creditors. So that is clear that to the extent that common law requires that, that is going to modify the duty under subsection 1. One can see there's a clear contrast. If one looks at the back at subsection 1, the primary duty requires the directors in pursuing and promoting the success of the company for the benefit of members, in doing so to have regard to a number of matters set out A to F. The contrast in language is clear. There, the directors must have regard to those matters. That is, in so doing, so in promoting the success of the company for the benefit of members, whereas subsection 3, the wording is entirely different. The duty is subject to any common law rule requiring directors to consider or act in the interest of creditors. So how does the modification that's required actually work? Where we are short of actual insolvency and creditors' interests only have to be taken into account. The answer we suggest is that pre-actual insolvency, the directors are required to promote the success of the company for the benefit of both members and creditors. So they continue to focus on the success of the entity, but in so doing, they must recognise that they are pursuing that for the benefit of both constituencies, and both sets of interests therefore need to be taken into account. So in all situations, it is the corporate entity's success that is the main target, and the question is for whose underlying benefit that is. And just for the court to note, that's entirely consistent, at least, with the explanatory notes. We have 331 and 332, which are at page 768, which notes that the duty under section 1721 is displaced on actual insolvency, but contemplates that it may be modified prior to actual insolvency. And again, we just note that we'll come back to the Company Law Reform Steering Group's reports, but the clause was proposed in the final report, clause 8, which one will find at 878, does provide for, again, the balancing of shareholder and creditor interests. Now, that clause, which we will come back and look at, because we'll look at the Company Law Reform Steering Group's output in more detail, interestingly does, as well as requiring a balance to be struck, notes that the weight given to reducing the insolvency risk increases with the risk of insolvency. And there's just a point to be made here in passing. There may be, in practice, and I emphasize in practice, a sliding scale here as regards the interests of members and the interests of creditors. I'm not for a moment suggesting that is part of the formulation of the duty, but suggesting only that in practice, in the application of the duty, it may well be that the more insolvent, the higher the risk of insolvency, the closer to insolvency the company becomes, the more creditors' interests will tend to be taken into account, at the expense of shareholders' interests if there is any conflict. And that's something that's recognised in the Kinsella case, which we'll again look at in a moment, 1064C, but also in the steering group's final report, paragraph 3.17 and 855. So, unless the court has any questions, those are our submissions in relation to the content duty. In which case I'll move on to first really contentious question between the parties, which is the question of whether the creditor duty exists at all. Question 1 in the written submissions. Now, in dealing with this, I'll remind the court briefly of our written case. Of course, at that stage, we didn't have the respondents' arguments because they came for the first time in detail in their written case. So I'll spend some time dealing with some of the points anyway raised in the respondents' case on this issue. Now, in our written case, we essentially make 4 points. We deal with authority, and we make the point that there is a huge weight of authority in support of the existence of what I'm calling shorthand the creditor duty. We've summarised this in our submissions, pages 57 to 63 and 66 to 70, so I won't go through it all now, but the broad highlights are that this is a duty which has become firmly entrenched in Australia post-Kinsella, in New Zealand post-Permacraft, and of course in this jurisdiction following West Mercia. Although not out of the blue in this jurisdiction in the sense that there were dicta moving in this direction from the House of Lords and the Court of Appeal before West Mercia in Horsley and Waite, Brady and Winkle. And there is no, second point is there's no UK, Australian or New Zealand judicial authority which actually considers the creditor duty issue which supports the respondent's argument. The third point that we make, which I'll come to in more detail, is that Section 172 does proceed on the basis that the creditor duty exists. We'll consider the effects of that. And the fourth is that as regards principle and policy, there's an overwhelming rationale for the existence of the creditor duty. So if I can turn then to the third of those points, the relationship really between the creditor duty and Section 172. Now, we do say that Section 172 proceeds on the basis that the creditor duty exists at common law. Parliament must be taken to have known and taken into account the common law, particularly when it referred to it directly in Section 172, subsection 3. And that includes, of course, West Mercia and all the English cases running up to the 2006 Act. As regards the effect of that, we don't say that, therefore, this court simply can't overrule West Mercia. We do say that it should be at least very slow to do so. It does raise the general issue of the relationship between this aspect of the common law, Section 172. Because the premise of Section 172, subsection 3, is that there is a common law duty based on 40 years' development by the courts. And that was clearly the basis of the decision not to codify this one aspect of directors' duties. It's clear that Parliament understood the West Mercia rule to exist. It's clear from the pre-legislative material, steering group material, the white papers, and we've set that out in highlight form, at least in our written case, at pages 63 to 66. Just by way of example, really, the Company Law Reform Steering Group's final report, paragraph 3.17, footnote 24, page 855, refers expressly to West Mercia, but the white paper, immediately before the legislation, March 2005, which included a draft bill, set out in the relevant clauses at 944 in the same form as 1723 eventually took. At 958, it's expressly noted in the notes that this preserves the current legal position. When the company is insolvent or is nearing insolvency, the interests of members may be supplemented or replaced by creditors' interests. So it couldn't be clearer that's the premise of the legislation. We also get that from explanatory note 332, and that's at page 768. Now, the respondents argue, well, there should be no difficulty in reversing West Mercia, despite the fact that it stood for 33 years, because they say, well, it's always been controversial. Now, with respect, we say that's entirely wrong. They haven't pointed to a single case in this jurisdiction, or indeed in Australia or New Zealand, doubting it. We've seen there's a wealth of authorities supporting it, including dicta in the Supreme Court and the Court of Appeal. And all the respondents are able to refer to is essentially some hand-picked academic, mostly historical articles, which they've cherry-picked particular points. Many of the articles not actually being focused on the creditor's duty at all. So it's wrong to say that this has always been controversial. West Mercia has, we would say, been well settled, at least judicially. Now, I'd like to turn to, now inevitably have to spend some time on questions of principle and policy. So it's the fourth point now we raised in the written case in relation to this question as to whether the creditor duty exists at all. Because the respondent's argument is that, as they put it, the creditor duty is conceptually unsound. They say it's wrong in principle, but the reality is, of course, they haven't been able to pull together any great tide of academic opinion to support that. Quite the contrary. But we need to focus, I would suggest, on the nature of the creditor duty and what the question actually really is. Some fundamentals to lose sight of. As indicated, the duty is owed to the company. The fiduciary relationship is between the directors and the company, and it always has been, pre the 2006 Act and obviously post. And as we've seen, the duty is owed primarily to the entity itself, or at least, I apologise, the primary focus of the duty is the entity itself, promoting its success. So the issue really is only for whose ultimate benefit that success is to be pursued. So it's only about the content of the duty, and it's about a particular aspect of the content of the duty. In many respects, the respondent's argument proceeds as if the duty were owed by directors to shareholders. They even use that phrase, they even say so in paragraph 33, subparagraph 2, page 115. I assume that's probably a slip, but it rather gives the game away. Now, this, of course, now begs the large question of what is the rationale for the creditor duty? Well, put very simply here, we make a couple of points, which will need some development. The context for the duty is a more modern conception of the company, entirely consistent now with the Companies Act 2006, which recognises that there are a range of interests behind the corporate entity. And the second overarching is that the question, therefore, is whether there are circumstances where the creditor's interests are sufficient to form part of the content of directors' duties. So I'll deal with those 2 points separately. The first one rather more quick. And as regards to the modern conception of the company, That's something that, of course, the common law has to take into account in the context of the Companies Act 2006. The Companies Act 2006 provides the statutory structure, and the common law naturally fits around it. Now, Section 172, which we've looked at, we would suggest overtly adopts that wider conception of the company. Because as we've seen in subsection 1, it focuses on success of the company as an entity, and it identifies numerous interests behind it. And subsection 3 expressly allows for creditors' interests potentially to displace that duty, content of the duty. So it's clear now that one does not just identify the company with the members alone. The company is, under the Act, treated as an enterprise in which the members and others have stakes. Now, the primary purpose we entirely accept is, at least while the company is solvent, to benefit members. That is not the only purpose. And this more modern approach hasn't, we would suggest, appeared out of nowhere. If I may, I'll just invite the Court's attention briefly back to the Seeley article from 1987, because on this too, it is prescient. First page references 4734. Where at the bottom of the page, Professor Seeley, under the heading, The Traditional View Under Challenge, says that it's against this background that the traditional rules and concepts of company law regarding directors' duties have come under challenge. This law, concentrated as it is on the interests of shareholders and no other group, is thought to be too narrowly focused. It's contended on many sides, moving over the page, that the law ought to allow or even require directors to have regard to other wider considerations as interests. There are demands for overt recognition of the claims of the company's workforce, its customers and clientele, its suppliers and creditors, more broadly the local community, the national interest, exports, welfare, the environment. And then if one goes over to 4738, under the heading Some Conceptual Problems, the company, Professor Seeley observes in the traditional model of the company as an object of directors' duties, it's perceived entirely in terms of the members, present and future. Proposed to refer to this concept of the company as the corporate membership. This simple model is inadequate when wider interests have to be reckoned. If directors are to be required to have a concern for, say, employees and creditors, it's no longer appropriate to regard the membership alone as the constituent body, so far as, for example, to entrust it with an unfettered power to ratify and condone directors' irregular acts. Then develops that over the page 4739. First full paragraph, all these considerations suggest that for the future it may be necessary for the law to conceptualize the company not as the corporate membership but as the corporate enterprise, as an aid to the formulation of new rules of directors' duties in cases where interests other than purely membership interests are affected. He goes on, I shan't read it out now, but in the balance of that page and the top of the next, to develop the concept of the company as a corporate enterprise, as an alternative to a corporate membership. And those developments are, or those observations are, we say, entirely prescient, because they effectively represent what Section 172, has done in substance. So that's the modern concept of companies we see it.
Mr. Thompson, can you hear?
I can, thank you.
I note that Professor Seeley on page 4738, and in particular treats the ratification principle as something which will need to be modified he says it's no longer appropriate to allow for it as an unfettered power if his modern perception of a company as being an entity with underlying stakeholders at all stages in its existence is to prevail. Now, when we move forward to 2006, we see in section 172 what you describe as a reflection of the plus side of Professor Seeley's and the modern side, but we see any cutting down of the ratification principle. I hope at some stage in your submission you'll deal with the problem, as it seems to me, that if we're talking about the common law, the ratification principle, I think, remains part of the common law and must somehow work alongside a wider recognition of duties as flowing from the stakeholder interest and credit.
My lord, yes, and we
Or for
certainly will.
Or for that matter, any other stakeholders than the members.
My lord, certainly we will be dealing with that, because it's a point that both sides have raised in the written case, and it is, we entirely accept, a highly pertinent issue. I mean, effectively, I think I'm right in saying that it's broadly common ground that there is a link between the two. We say, if we're right about the creditor duty, it follows that the ratification by shareholders must be limited accordingly, and there's some judicial support for that. Whereas the respondents say, well, because the ratification principle is on their view inviolate, then therefore that's a reason why the creditor duty shouldn't exist. So we start from the same point but end up in very different positions. But I will certainly be coming to that. Yes, absolutely. Now I want to talk about the second, perhaps larger issue, was taking on board that more modern conception of the company as we describe it. Are creditors' interests ever sufficient to require consideration by the directors when they're carrying out their fiduciary duties? Now, we say that the creditor duty arises when and because the creditors have a sufficient practical interest in the company's success or failure, and therefore in the outcome of directors' decisions. In other words, when they are sufficiently affected by them, when they have a sufficient stake in the company and the decisions made on its behalf. What does sufficient mean? Well, essentially, it means sufficient relative to the members' stake in the company and its decisions. And putting it very briefly, where there is actual insolvency, the practical stake in the company and the decisions taken on its behalf of the creditors is greater than that of members, whereas pre-actual insolvency, it is not greater than the member's stake, but sufficient for creditors' interests to be taken into account. And here we've got to look at what's been described as the quasi-proprietary rationale in the Kinsella case, because that is part of the explanation as to why creditors' interests are in those situations sufficient to be at least taken into account. Now, the court may have had a chance to look at it, but the important passage, and it is quite an important one, is at page 1061 at A to C. 1061 A to C. And as I say, it's been described by both sides as the quasi-proprietary rationale. It would help to read it out, or simply to invite the court to read it. The passage starts actually on the very last line of the last page, but the key bit is on the third line on page 1061 down to the end of that paragraph.
Well, if you give it us a moment, we can read it for ourselves.
Thank you. Now, what it is doing is focusing on the assets of the company, and it's referring to the creditor's indirect and practical, so non-legal interest in the company's assets where there's actual insolvency. All it's doing is explaining why the creditor's stake in the decision-making of the company becomes greater at that point. How it is that the creditors have a stake in the company's success or failure at that point, which is bigger than the members' stake in that success or failure. It's never been suggested, first, that the creditors actually gain any proprietary interest as a matter of law. That obviously remains with the company. It's a purely practical point. And all that Chief Justice Street is saying here is that when the company is actually insolvent, there's clearly a prospect that the company will end up being put into liquidation. And if it ends up in liquidation, then first the shareholders lose control. So they no longer control the affairs of the company. And second, of course, a statutory regime is implemented through the liquidator, which is entirely in creditors' interests if it's an insolvent liquidation. And under that regime, the assets of the company will, of course, be realised in order to pay creditors. So simply, in that event, creditors benefit from the assets and shareholders don't. So it's entirely practical, it's entirely prospective, it's something that the company is exposed to, but is not an inevitability in the case of actual insolvency. And it's not just about the benefit to creditors that creditors get out of the assets potentially, but also who controls them. The prospect that it won't be the shareholders, it won't be the members anymore, it'll be a liquidator. And so one can contrast that position with the situation where the company is amply solvent, where the company's assets will be used to promote the success of the company for members under section 172 subsection 1, and make profits, hopefully, and distribute them, hopefully, to members. So where there is actual insolvency, it's the creditors who have the greater stake. And actually, an important point as well is it's not just that creditors have a greater stake. In most cases, shareholders will have very little interest in the outcome of decisions at that point, because they don't have any immediate economic stake in the outcome of those decisions. And so the important point here is that the rationale for the 172 subsection 1 duty has disappeared, or at least been severely curtailed. And if, on the other hand, if we're wrong, and there is no creditor duty which will in any way modify section 172 subsection 1 duty, then this will, we say, produce some highly undesirable outcomes, because what it will do is leave the 172 subsection 1 duty unmodified, and therefore require directors to continue to promote the success of the company exclusively for the benefit of members, without taking into account even creditors' interests. So that could obviously, in certain circumstances, end up with directors feeling that they are forced to attempt radical, perhaps desperate steps to try to avoid liquidation and restore solvency, regardless of anything else. Because if the 172(1) duty applies unamended, then that's what they will be required to do. They will be required to try to promote the success of the company for the benefit of members. And that's the only form of success in that situation which could benefit members. So that's essentially our case in relation to that. But there are numerous criticisms that are made by the respondents in their written case of the quasi-proprietary rationale and the way we put our explanation of the justification for creditors' interest being taken into account. I need to deal with those at least briefly. Now, the first is an argument that involves the respondents criticising the quasi-proprietary rationale because they say that it's wrong to suggest that shareholders have any proprietary interest in the company's assets in a position of ample solvency. So it can't be the justification for the general position that members' interests take priority. Our response is simple. Consider is not referring to any actual legal proprietary interest in the company's assets. It's only a practical interest. Second point the respondents make, also in paragraph 32 of their...
But what does that mean?
What does the practical interest mean, my lord?
Yeah. What does it mean to say that in a practical sense, the company's assets are the creditor's assets and not the shareholder's assets? We know in law they're not either.
Indeed, they're law not either. And what I understand the Chief Justice to be saying is that, despite that, in practical terms, where the company is actually insolvent, what is liable and indeed likely to happen is that if the company goes into liquidation, then necessarily those assets are going to be realised for the benefit of creditors. So they are the ones, the creditors as a body, are the ones who are going to benefit from decisions which either swell or reduce those assets once the company's got into that situation of actual insolvency. I mean, the same way that the shareholders don't have any legal proprietary interest in the company's assets. One of the points that respondents make, they say, well, they're actually really interested only in the surplus assets, so any that could be distributed to the members. But actually
apply to natural persons, where the analogy would be creditors and the trustee in bankruptcy.
Well, in relation to a natural person, I mean, there isn't really any analogy with members. The trustee in bankruptcy, we would suggest, is analogous to the liquidator, and in an insolvent liquidation or in a bankruptcy, is going to be collecting in, realising, and distributing the assets for the benefit of the creditors.
Yes. So, in a practical sense, the assets of the individual who's on the verge of insolvency are his creditors' assets.
Yes, if he's actually insolvent or on the verge of insolvency, yes.
Yeah, I see.
And if he's amply solvent in a practical sense and in a legal sense, they're his. Thank you, my lord. Now, the respondent's second point here is to say, well,
I think the card has a question for you.
Just following up the analogy of the natural person, the origin of the rules against transaction at an undervalue are, I think, the concept that the bankrupt individual or the person on the brink of bankruptcy is required to take account of the interests of his creditors because of the insolvency. Are you using the quasi-proprietary rationale in the same sort of sense? There isn't an actual trust at that stage for the creditors, but the very fact of insolvency or pending insolvency requires the individual to take into account and give priority to his creditors when he is going to become actually insolvent.
my lord, in an approximate sense, yes, we do.
Yes.
I mean, we are clearly focused on an entirely general aspect of directors' fiduciary duties, and the quasi-proprietary rationale set out in Kinsella is a very, we would entirely accept, high-level and general explanation as to why it is that creditors' interests should be taken into account. But there are, of course, other that very, very broad rationale forms the basis for other rules of law as well. Indeed.
Yes, because as Lord Reid says, there is no actual proprietary interest for the reasons that you readily concede. It is a much broader rationale that an insolvent person is required to take account of the interests of his creditors by virtue of his insolvency.
Absolutely, and here we have, because we have the separate corporate entity and we have directors who owe duties to it, the way in which that particular concern is manifest is through a modification of the content of that duty, so that directors are no longer required to focus primarily on the interests of members, but to start to think about the interests of creditors as well.
Yes, but I don't wish to take you out of turn, but where the analogy with the principle underlying the individual insolvent breaks down in your case is requiring a duty on the directors at a stage before actual insolvency or imminent pending insolvency, because there is no such duty on an individual, I think, to take account of his interest, the interests of creditors, at a stage where he is not imminently or pending insolvent.
Well, indeed, and the analogy is, as I say, no more than approximate, based on a similar concern. And I will deal in some detail when I get to question 3 on as to the justification for requiring an amendment, effectively, to the director's duties pre-actual insolvency, and exactly where it should be.
I don't wish to take you out of turn, Mr. Thompson. Thank you.
Thank you, my lord. Now, the shareholders have an interest in the same practical sense in all of the assets of the company, not just those which might be surplus and available for distribution, while the company is amply solvent, in other words, where there's no risk of insolvency. Simply because at that stage, the enterprise is, under the Section 172 subsection 1 duty, being pursued ultimately for their benefit, to produce profits to distribute in the long term. So the practical, and I emphasize practical, interests of the two do explain the underlying justification for the Section 172 subsection 1 duty, and for the modification to it pursuant to subsection 3. Now, the respondents say, well, that rationale is flawed because it depends on an analogy between the shareholder's position in the amply solvent company and the creditor's position in the insolvent company, when in fact respondents say, well, those positions are not closely analogous. But this doesn't depend on any precise analogy between the creditors and the members of those two situations. The fact that their positions are not precisely analogous doesn't matter. The issue is which group, with their necessarily different rights and interests, has the greater practical stake in the company's activities and the outcome of directors' decisions. Now, fourth, then the respondents argue, well, the quasi-proprietary rationale doesn't explain why generally shareholders' interests are prime, because they say, the respondents say, that's really explained by the fact that it's the shareholders who appoint the directors. As they put it, they say there is privity between the company and the members, but the creditors, they say, never have such privity. Therefore, they argue, well, Section 172 duty must always focus on shareholder interests, because that rationale that the shareholders have appointed the directors always applies. Now, we respond to that in a number of ways. The first point main point really is that the duty to promote the success of the company for members is not based on the fact that it is normally the case that shareholders appoint the directors. It's true they normally do, but they do so on behalf of the company. And they create, therefore, legal relations between the directors and the company. They don't create legal relations between the directors and the members. So the appointment gives the directors powers to act for the company, not for its shareholders. Those powers, of course, in relation to the company's business and assets. That's the inevitable effect of separate corporate personality. And two examples demonstrate this. If you've got only one class of shareholders who are entitled to appoint, because there's a class of non-voting shareholders, but nevertheless, although it's only the voting shareholders who are in reality making the appointment, the directors have still got the same duties to the company, which mean promoting the success of the company for all shareholders, not just the ones who made the appointment. And take another example. If you've got a not-for-profit company, where distributions to members are not allowed, the directors are still going to be appointed by the members, but the members have no financial stake in the business and assets. And we've seen from subsection 2, section 172, that in that situation, the duty is to promote the success of the company, not for the members' benefit, but to achieve the non-profit making purposes of the company. So there simply isn't this link between appointment by members and the content of the duty that directors owe to pursue the success of the company. And the respondents make this basically the same distinction by saying, oh, well, only shareholders have privity with the directors and creditors never do. But actually, that's misconceived in any event, because the directors do not have contractual privity with shareholders. This point is made on the basis of the statutory contract represented by the Constitution of the company under Section 33 of the Companies Act 2006. But of course, the directors are not party to it. Directors are put into a legal relationship with the company by virtue of being appointed, but not into any legal relationship directly with the shareholders. They don't owe the shareholders fiduciary duties, and they are not party to a contract with the shareholders either. Now, my lords, my lady, that might be an appropriate point, I think. Break coming up to 11:45, if that's convenient to the court.
Yes, certainly. Thank you, Mr. Thompson. We'll adjourn then for about 5 minutes. I think we're ready to resume now. Mr. Thompson.
Thank you, my lord. I've been dealing with various points that respondents make in relation to the rationale for the existence of the creditor duty at all. I just want to move pretty quickly through some more minor points they make, having dealt, I hope, with the major ones. One point they make is that they actually refer back to the pre-2006 law to argue that in relation to the old duty to pursue the company's best interest, they say it was well established that the company's interests were those of the shareholders as a whole. The reality in our submission is that wasn't clearly established at all. Various different formulations were used by the courts referring to the interests of shareholders as a body or to the corporate entity. And one can see that from the Gaiman case that the respondents refer to, particular passage 1959 G2H, and also, just for the court's note, the correct position pre-2006 is basically set out in an article by Professor Worthington in 1990, which the respondents cite, in particular page 1210, pointing out that there wasn't any clear formulation as to what the company's interests meant pre-2006. There were different judicial interpretations, and for what it's worth, Professor Worthington herself preferred the view that it was the corporate entity whose interests had to be pursued. But it's a sterile debate now because, of course, we now have the 2006 Act making the position entirely clear. Another minor point is some reliance by the respondents on an essay by Dr. Finn going all the way back to 1977 in support of the argument that the company as a whole means the company not as a commercial entity, but the corporators as a general body. Now, some very short points on that. That, of course, was an article from 1977 before the creditor duty was even developed and long before the 2006 Act. But also, it does involve adopting an extreme position, which the author himself recognised, logically actually required that directors should owe duties directly to shareholders, which, of course, plainly they don't. So that is of, in our submission, no assistance to the court. The respondents also make a point, this is paragraph 34(1) of their written case, in relation to the availability of creditor derivative actions. They argue that the fact that creditors can't bring a derivative action in the present state of the law anyway is inconsistent, they say, with the existence of the creditor duty. We say not so. The derivative claim, of course, is an exceptional procedural device that allows, in rare circumstances, a corporate claim to be brought to the court by a minority shareholder. And it's not surprising or remotely inconsistent with the creditor duty that creditors can't bring derivative claims. The exceptional device of that sort is arguably at least not required for creditors. Creditors can put the company into liquidation or administration, and then the office holder will, of course, pursue the claims acting in the interests of creditors. And that's, of course, quite an important practical point, because that is how normally any breach of duty claims based on the need to take account of creditor interests are going to, in fact, be pursued. They'll only be pursued in the event that the company goes into liquidation or administration, and then by the office holder. Now then, again, in paragraph 34(2), the respondents advance an argument that they say that the fact that there are no conflict duty, they put it under sections 175 to 177 of the Companies Act, require disclosure to shareholders, mean that shareholders retain primacy even on insolvency. But our response to that is very short. It's clear that under 175, a conflict may be authorised by the directors. That's page 726, just for the court to note, not the shareholders. And the duty to disclose an interest under 177 that they refer to is one that requires disclosure, again, to the directors, not the shareholders. So the point's misconceived, at least under the 2006 Act, whatever the position might have been prior to that. So there's nothing in that. They then, at 34, subparagraph 3 of their written submissions, advance a point that they say that if we're right about the creditor duty, somehow that must mean that shareholders must also owe fiduciary duties, if West Mercia is right. Now, we say that's misconceived. It's not an issue that courts have had to consider, and it's not an issue for this court today. It's not surprising that it hasn't been considered, because shareholders very rarely exercise powers of management. If they do, they may well become de facto directors and owe fiduciary duties accordingly. It's not inconceivable that in circumstances short of that, there may be limits on the powers that shareholders, or the exercise of powers by shareholders. And it's worth noting, well, that's very much not for today, that there's some academic support for that possibility. And I'll just refer again for the court to note, again to the Worthington article at 1200, and again the Seeley article 4746 to 8. But it's not a matter for today. If there were to be any sort of limit on shareholders' powers being exercised, one suspects it might not involve fiduciary duties as such, for obvious reasons of principle, but possibly just limits on the ability of shareholders to act effectively We have that already in the case of ratification, which I'm going to come to, and also, of course, the Allen and Gold Reefs principle. As regards its relevance to the creditor duty, it has none in our submission. Now, they also submit, paragraph 35, that it's an impediment to the creditor duty that creditors are not an organ of the company. That isn't relevant. It's really just another way of putting the appointment argument I dealt with earlier. Creditors are not, of course, an organ of the company, but that's not determinative of whether their interests are entitled to be taken into account. They also make the specific point that there's no relationship, they say, of trust and confidence between creditors and the company or its directors. Again, that's entirely irrelevant. This is not about any separate duty owed by directors directly to creditors at all. This is simply about the content of duties which are clearly owed by the directors as fiduciaries to the company as a corporate entity. Now, there is one more significant point they make as regards to the rationale, which is worth looking at, because in paragraph 36, they say, the respondents, that their submissions, as they put it, don't detract from the numerous statutory duties imposed on directors to protect creditors. Now, they clearly do, in fact, in particular in relation to section 214 of the Insolvency Act 1986. Because the respondent's case is that the 172 duty to pursue the success of the company for members applies in all circumstances, including actual insolvency, however dire. And so there is in our submission going to be quite an acute conflict for directors between that duty, if that really is the law, on the one hand, and their potential liability under section 214 of the Insolvency Act 86 on the other. Now, for this purpose, we need perhaps just to briefly look at section 214 just to remind ourselves of its effect. We can find it at page 776. Start a bit at the bottom of 776 and going over 777. What it does in relation to a director is allow the court, as it says at the top of 777, to declare that that person, the director, is liable to make such contribution, if any, to the company's assets as the court thinks proper. And then in subsection 2, it says this applies in relation to a person if the company's gone into insolvent liquidation. So it's gone into liquidation at some time before the commencement of the winding up. That person knew or ought to have concluded that there was no reasonable prospect that the company would avoid going into insolvency. And at subsection 3, it says that the court won't make a declaration in respect of any such person if satisfied that that person, third line of subparagraph, subsection 3, took every step with a view to minimizing the potential loss to the company's creditors as he ought to have taken. Now, that is quite a demanding standard, very demanding standard, where it applies. So just stepping back from that, what this section does is to apply in a relatively narrow set of circumstances where the company has gone into insolvent liquidation and the director ought at some time before that to have concluded there was no reasonable prospect of the company avoiding. But when those conditions are satisfied, in order to avoid liability, the director has the demanding standard of having taken every step with a view to minimizing the potential loss to the company's creditors as he ought to have taken. And the point here is that if the respondents are right about section 1721 duty and the lack of any modification to take account of creditors' interests, then directors are going to come up in practice against a real conflict between complying with their Section 172, subsection 1 duty on the one hand, and on the other, avoiding liability under Section 214. Because an unmitigated, unmodified Section 1721 duty would require the directors to cling to any possible hope of survival for the company and a return to solvency, because it's only through that route that they could be promoting the success of the company for the benefit exclusively of members, even if that means some sort of bet the farm type strategy. Because anything else will just result in liquidation. But that's going to be completely the opposite of what's required under Section 214 if the directors are going to avoid personal liability. I mean, it's true that Section 214 doesn't impose a duty as such, it's a liability. So it's a different type of legal animal to the directors' fiduciary duties. But the practical problem is that the directors are going to be torn in two completely different directions. By contrast, of course, if the creditor duty exists as we submit, then at that point, either if it's close to actual insolvency, then the creditor's interest will have to be taken into account, and that's entirely consistent with the Section 214 position. Or if it's actually insolvent, then the creditor's interest will be paramount, and that's entirely consistent, again, with Section 214. So there is.
I think first Lady Arden and then Lord Briggs have questions for.
Sorry,
Thanks
thank
so
you.
much. Just 2 points on Section 214, if I may. Your submission was in terms that it only imposes a duty, and that is true if you look at the precise words. But is it not also possible that it is reflecting some implicit obligation under the general law? And my second question is this, that you have focused on the real conflict that exists between the Section 172 duty and Section 214 as you have described it. But you have not yet dealt with the conflict that arises if you are right that there is a duty to take into account the interests of creditors at a point in time when there's a real risk of insolvency, and the Section 1721 duty. And are you proposing to deal with that later?
My lady, in relation to the second question, yes, I am.
Good.
Because I'll deal with that when I come to the. When I've dealt with the question of whether the duty exists at all, then the question of whether it exists short of actual insolvency, and if so, when. At that point, yes, I will deal with that point.
Fine. And then the other point then is really, although Section 214 is establishing a liability which only arises in a liquidation, might it not also be reflecting certainly the legislature's view about some implicit obligation under the general law to the same effect?
Absolutely, my lady, and essentially that's rather more elegantly the point that's underlying the point I'm making here, because it would be, should we say, extremely surprising if there was such a stark conflict between what on the respondent's case the director's duties require and what in practice is required under Section 214. And the answer to that is, as my lady posits, that actually Section 214 does indeed reflect, indirectly at least, what is required by the law of directors more generally. So there should not be a consistency, and there isn't for that reason.
Thank you.
Mr. Thompson, isn't the critical difference between your supposed common law duty and the Section 214, what you might call implied duty in 2143? I agree it's expressed as a liability, but it effectively says this is what you've got to do if you want to be liable. But the 2143, let's call it quasi-duty, cuts in only once the director realizes that there's no light at the end of the, or realizes or should realize that there's no light at the end of the tunnel. Whereas what you're submitting is that, in fact, the what you call the creditor duty becomes paramount once the company is insolvent. Now, in the real world, directors are frequently struggling with companies that are actually insolvent, either on a balance sheet or more likely a commercial basis, but do think there's light at the end of the tunnel. And I'm wondering if there isn't a slight tension between an assumption that the common law puts the creditors in the driving seat in terms of the interests that have to be taken into account as a paramount obligation at the latest on the onset of insolvency, whereas Section 2143 suggests that actually you've got to do everything you can to help the creditors only at a later stage in the process.
Well, my lord, I think it's fair to say that the triggering events, if I can use that inelegant phrase, in relation to Section 214 and in relation to the creditor duty that we advocate are different. And in a way, they're different in two directions. As my lord says, and we respectfully agree, it could be the case that a company is actually insolvent, but it's not yet in 214 territory because there is some light at the end of a tunnel. So it may be that they don't coincide in that way. They also may not coincide in the other direction, in the sense that you can have a company which is not yet actually insolvent, but where actually the directors ought to realise that the writing is on the wall in very big red letters, and so 214 does apply. So the two things don't coincide at all, and I'm not for a moment suggesting that if the respondents are right, there will always be a horrible conflict for the director between avoiding 214 liability and his duties. All I'm saying is that in many cases there will be. And the two are not entirely coincident, and we're not suggesting they are. If that assists.
I was just saying,
Thank you. Yeah. So then there are a number of points the respondents make which are not about the rationale for the creditor duty specifically, but particular problems that they identify. I mean, the first is the question of ratification, if I can turn to that. Now here I'm dealing really with the question of ratification as an objection to the creditor duty as deployed by the respondents. I'll have more to say about it in due course as regards our submissions about exactly where the creditor duty should arise and why. This is just dealing with the respondents' argument that the law of ratification would be, as they put it, undermined by the creditor duty. Now, as I say, it appears to be that it's common ground that the two need broadly to go hand in glove, so that the creditor duty and some limit on the ability of shareholders to ratify need to coincide. It's simply, as I say, that we draw rather different conclusions. The respondents argue that ratification principle should be sacrosanct and overriding, and shareholders should always be entitled to ratify breaches of duty owed to the company, and that therefore, as a consequence, the creditor duty can't exist. Now, the position is, as we submitted, that the company does not, where the creditor duty applies, itself lose the power to ratify. There is just a limit on the shareholders' ability, shareholders' power to do so on behalf of the company. So the breach doesn't become unratifiable. And in particular, an obvious example is that if the company proceeds to liquidation or administration, then the office holder can ratify. And equally, if the company then recovers and becomes amply solvent again, then the shareholders can once again ratify. So it's not really an issue about in the law of ratification, it's an issue in company law as to who and when, who has the power on behalf of the company to ratify and when. ratification is still by the company. The company can still ratify, doesn't lose that ability. It's simply a question of which organ, if any, can actually ratify in particular circumstances. Now, it may well be that between those two situations where the company has not yet either gone into liquidation or administration or recovered to ample solvency, there may well be a period where temporarily the shareholders cannot ratify, and therefore, in practice, the company isn't in a position to ratify the breach. But it's only temporary, and it isn't, in our submission, remotely problematic. There's no issue about the company's capacity to ratify. The temporary absence of an organ able to ratify is, as I say, unproblematic. It's not necessary as a matter of law that a company should always be in a position to ratify all wrongs. Ratification is, in a sense, exceptional. It's curing a wrong done to the company for good and all, forever. So, in practice, a limit to the shareholders' power to ratify is indeed a necessary corollary of the existence of the creditor duty, because otherwise the protection provided by it may well be completely undermined. But a temporary inability on the part of the shareholders to ratify the company is simply unproblematic. Now, as I say, I'll return further to the question of ratification, how it relates to the creditor duty in making submissions about exactly when the creditor duty should apply. Now, respondents say that therefore, if we're right, there'll be categories of duties which simply can't be ratified, unratifiable duties. Well, that's not the case. There will simply be circumstances in which breaches cannot be ratified by the shareholders, which, as I say, are necessarily, in their nature, temporary. And in any event, the law already recognises categories of breach which are unratifiable. Fraud on the minority doctrine, unlawful dividends, for example. Now, there's the further point that the respondents make. They say, well, if the shareholders can't ratify, then it must follow that they can't decide to sue on behalf of the company either. And they refer to the dictum of Lord Justice Russell in Bamford and Bamford. I'll deal with that briefly so as not to take up too much time on it. The fact is that the question of ratification is an entirely different issue to the question of whether the company should sue. It doesn't follow that just because shareholders can't ratify, that the shareholders can't decide that the company should sue. The power to ratify and the power to decide to sue are simply different. The decision not to sue at any particular point doesn't involve any ratification, which is an adoption of the invalid act as an act of the company and a consequential release of any liability for good and all. The decision to sue or not to sue is a much more limited decision. And Bamford isn't authority to the contrary, doesn't really address these issues at all. Dictum of Lord Justice Russell, which for court note is 1353, is simply supporting his conclusion that the shareholders could ratify a flawed allotment of shares by pointing out that they obviously could have decided to sue or not. It certainly wasn't saying that the two powers are inextricably linked, or that an organ that can't ratify can't decide to sue. It simply wasn't addressing those issues at all. Now, the respondent's final point in relation to ratification, this is paragraph 40 of their written case, is to say, well, they they argue that the court should recognise neither the creditor duty nor restriction on ratification, and they reject our argument that that position would allow shareholders to ratify the situation of actual insolvency potentially serious misappropriations of the company's assets. Now, our point in relation to this and the risk of misappropriation of assets being ratified is essentially this. It's not about distributions to shareholders. The company's assets may well be misapplied in favour of directors or others to the detriment of the company as an entity in breach of fiduciary duty. And on the respondent's case, even if the company is in a situation of actual insolvency, the shareholders can ratify, despite the fact that shareholders are not prejudiced by these misappropriations. The creditors are the ones who are prejudiced. But it would, in our submission, be an absurd position for the law to get into, that ratification by shareholders who have no actual practical interest can take place. And it's suggested by the respondents that the ultra vires rule is of sufficient protection, but in our submission it certainly is not. There's very little left of it after the 2006 Act in any event. Most companies have no object clauses now, and even if they do, the effect of a breach is not voidness, but it simply goes to authority, so it provides no protection in that situation. Now, the respondents then go on to argue that the creditor duty would undermine various statutory provisions, as they put it. And I want to now deal with that, if I may. The first one is to go to section 214 and say, well, the creditor duty would undermine section 214. Well, it does. Section 214 does, in our submission, form a rather different function. Obviously, they both potentially result in liability, but that's the only direct purpose, at least, of section 214. It's intended to allow the assets of the company in liquidation to be swelled for creditors. By contrast, directors' duties are primarily to guide behaviour, to tell the directors how to act. The question in the boardroom should not be, well, what's our risk of liability, or at least not only that, it should be, what does the law require us to do here? What should we be thinking about? And that's the primary function of directors' duties. So they perform different functions. So the fact that there's an overlap in the liabilities that may arise from the two is not a basis for inferring some limitation on directors' duties accordingly. But second, even if one ignores the wider functions of the creditor's duty, there's still no reason to infer limitation or exclusion. Section 214, liability compared to liability arising from a breach of the creditor's duty, is different. Section 214, as we've seen a moment ago, is more rigorous and demanding in setting the subsection 3 objective standard, but it has a narrower application, as we've seen. So only when the company does eventually go into liquidation, and only when at the time of the relevant decision there's no real prospect of avoiding insolvent liquidation, and the director knew that or ought to have realised. So it's a stronger remedy, also provided, but in much more limited circumstances. So it's not remotely inconsistent with the creditor duty. It adds something, section 214 adds something where it applies, but it's not intended to be comprehensive. It's not intended to push out of the way the more general duties of directors. In any event, what's being argued for here is effectively a statutory exclusion of the creditor duty impliedly through the introduction of section 214, which is a very high hurdle. Section 214 was new in the 1986 Act. At that point, creditor duty had been recognised only to a limited extent. It's true in dicta in the House of Lords and in the Court of Appeal. It's highly unlikely that Parliament can be taken to have impliedly excluded that nascent development. One can't divine that intention from section 214. There's no authority supporting any proposition to that effect. And Parliament's intention, of course, by 2006 was very clearly not to exclude creditor duty on grounds of the existence of section 214, because section 172 subsection 3 expressly preserves common law creditor duty such as it is. The more fundamental point perhaps here finally is that, and this applies also to the section 239 argument I'm going to go to deal with in a moment, the respondent submissions in our submission rather get it the wrong way round in terms of the relationship between the common law duties and the statute. The director's duties arise from the relationship between the company and the directors and are fundamental and entirely general, even before the codification in 2006. And the liabilities that are imposed under the Insolvency Act 1986 are really an additional overlay. And that's the correct relationship between the two in our solution. Now, the respondents make a similar point in relation to section 239 of the Insolvency Act, which, for the court to note, is a 779 bundle. That is the provision that allows relief in an insolvent liquidation in relation to preferences. And the respondent's argument here is that, as they put it, in section 239, Parliament has struck a careful balance, as they put it, between the integrity of the pari passu principle and the security of transactions, which they say will be disturbed if the creditor duty applied to preferential payments. And this appears to be another argument for the proposition that therefore the creditor duty cannot exist. And the premise of this argument, of course, is that the duty would otherwise be recognised. Otherwise, there's no point in addressing this. So the question is, again, did Parliament intend to exclude the creditor duty by enacting section 239? Again, it's a very high hurdle. There's no express exclusion. It's only potentially, if anything, implied. And there's just nothing to support such an implication in the wording of the Act. It doesn't purport to be a code or an exhaustive set of remedies. In fact, we do have, if one goes over in the same step, in the same part, to 784 and section 2414. This is in the same set of sections dealing with section 238 transactions at an undervalue and also 239 preferences. On page 784, we have the provisions of subsection 4 of section 241, which says the provisions of sections 238 to 241 apply without prejudice to the availability of any other remedy, even in relation to a transaction of preference which the company had no power to enter into or give. So that, in our submission, is a pretty clear answer that Parliament was not introducing section 239 intending to exclude or limit directors' duties. And again, perhaps dealing with this relatively quickly, again we have a situation where the two types of claim under section 239 and under the creditor duty are really dealing with different things, and they have different elements. 239 requires a payment to an existing creditor or surety, and that's obviously not required in relation to any breach of fiduciary duty claim for particular periods prior to the liquidation in relation to which 239 applies. They aren't relevant to breach of duty claims, and there has to be a desire to prefer. And again, that's not relevant to breach of duty. The targets are actually different because 239 is directed to recipient liability. The liability potentially is of the recipient who receives the preferential payment rather than the director, who of course is the primary target of any claim for breach of duty. Remedies are different. There's a broad remedial discretion under 239. And so the breach of fiduciary duty claim may be available where there is no 239 claim and vice versa. There is an area of overlap, but it's limited. It's a practical benefit to office holders, and it really isn't unusual or surprising. Now, moving on then,
Just before you do,
So,
are there any common law remedies in English law for transactions at an undervalue and unfair preferences, or are the remedies now all statutory?
well, in both cases, my lord, there may well be, if we are right about the existence of the creditor duty, there may well be claims for breach of fiduciary duty against the directors responsible.
But are there any common law claims against the recipients?
Well, they would arise if, in both cases, they would arise on the basis of constructive trust liability on the basis of knowing receipt. Slightly curtailed what I was going to say in relation to Section 239, because that's an important distinction, because in relation to 239, the liability of the recipient, where a preference under the statute is established, doesn't depend on the state of mind of the recipient. At least where the recipient is a direct recipient from the company. There are limits where the recipient is an indirect recipient, but in relation to a direct recipient, the state of mind isn't relevant. Whereas, of course, in relation to a constructive trust claim, it's highly relevant. So that again just emphasises that the two are dealing with different situations. There is an element of overlap. It's a bit like Section 214. There may be some overlap, there may not, but there are common law claims actually in both cases. In relation to transactions and undervalue, my lord's other point, again, there would be potentially a constructive trust claim in relation to the recipient.
Yeah, well, thank you very much. It's just because in the Scottish provisions which followed, Section 242 and following, there were also and are common law remedies for gratuitous alienations and unfair preferences, which coexist with the statutory regime. That's fine. Thank you very much.
Thank you, my lord. Now, the final point.
Could I just ask you whether 241 subsection 4 connotes any approval by Parliament of West Mercia?
Well, my lady, it may well do implicitly, because it certainly recognises the possibility of other claims. Well, though,
Thank you.
one needs to be careful with the timing, actually, because this is the 86 Insolvency Act. West Mercia was reported in 87. I'm not quite sure of the exact timing of the decision in West Mercia. So subject to that, then yes, but there is that caveat. I mean, West Mercia, I think, also refers to an earlier case, Washington Diamond Mining. A similar point was, or similar liability was identified on the basis of breach of duty at common law. So if not directly West Mercia, at least the principle that was then flagged up rather more evidently in West Mercia, yes.
West Mercia, the decision was November 1987.
Thank you very much. In that case, it couldn't have impliedly approved West Mercia itself, but the principle, yes. So the final point in relation to the existence of the duty is really the respondent's argument that the existence of the duty is, they say, inconsistent with the Salomon case and a Court of Appeal case called Wincham. Deal with those now. In relation to Salomon, the short point is that none of the issues that arise in this case was addressed in the House of Lords in Salomon. There's no attention to the content of the director's duties and no attention to the question of whether shareholders are able to ratify on behalf of an insolvent company. All that respondents can actually say in relation to this is that in holding that approval by the shareholders was effective to prevent rescission of the contract but transfer of the business, excuse me, in that case, as they put it, the House of Lords did not think it relevant to inquire into the company's financial circumstances at the time when the contract was adopted. Now, it's hardly surprising, first because the creditor duty wasn't contemplated at the end of the 19th century. It was obviously a much later development. I mean, secondly, the evidence wasn't that the company was insolvent. I mean, we can see that if one looks at, perhaps one doesn't need to turn it up, but the reference is page 3392 in the second half, which is the findings of fact, but we can see they're taken from the judgment, in fact, of Lord Watson. We see that from 3390, where at 3392, it said the evidence shows that before its transfer to the new company, the business had been prosperous. It yielded the appellant annual profit sufficient to maintain himself and his family and add to his capital. It also shows that the date of transfer, the business was perfectly solvent. So there wasn't on the facts any question about the solvency of the company. So the House of Lords had no basis for considering the issues which the respondents say it was striking that it didn't consider. So there really is no assistance from Salomon at all. And in relation to the next case, Winsham, again, this is a case decided at a time when the question of the creditor duty had not even been raised, and it just does not address any of the issues on this appeal. It wasn't a breach of fiduciary duty claim. In fact, it was a claim that liability to pay for shares had not been discharged. And we can see that the real question was identified as whether a valid payment had been made for those shares, and that's the top of page 643. So that was the question: was the payment made a valid payment for shares? Now, there wasn't any other claim for relief, compensation, or constructive trust or anything else. And the Court of Appeal held that it had been a valid payment, disagreeing with the Vice-Chancellor, whose view is recorded at page 641. Part of the reasoning, it's true, at 643, slightly further down, is that the directors do not owe fiduciary duties to creditors. It's about 3/4 of the way down, 643. And that's clearly correct, but it's not an argument about the content of the duty to the company. This is simply an observation in passing that no duty is owed by the directors to the creditors. Clearly correct. It's not about the content of the duty owed to the company. There's no finding on that, and it's no authority on that question. And again, it's not surprising because at that stage, it wouldn't have occurred to the courts or the advocates in the 19th century that was relevant. So there's no relevance in that case. So, my lords, my lady, that is what I've got to say about the question of whether the creditor duty exists at all. And unless the court's got any questions on that, I was proposing to move on to the question of if it exists, when it arises. In particular, is it only on actual insolvency, as the respondents suggest? Well, in relation to that, as I indicated in setting out the roadmap, I'm going to split it down into two sections. I hope that's not inconvenient, but the first is dealing with the respondents' contention, contrary to the Court of Appeal's findings, that the duty should only arise on actual insolvency. And the second section will deal with the question of if it is pre-actual insolvency that the duty arises, precisely when does it arise? Because the second part of that is essentially our appeal against the Court of Appeal's findings. So in relation to that, this question of actual duty, that our position, of course, is that, actual insolvency. In relation to this, our position, of course, is that the duty is triggered well short of actual insolvency, and there's a real risk of insolvency. But as I indicated, the content of the duty is different depending on whether one is before actual insolvency or at the point of actual insolvency. Now, the respondent's position, on the other hand, is really a range of different positions. Their argument at this stage is that it's actual insolvency only that is the trigger factor. They do have a fallback position, which is to say, well, if it's not just actual insolvency, it's alternatively where insolvency is at least imminent and probable. So there's a question of imminence, and I will deal with that. So here I'm dealing with the main argument of respondents, that essentially the rationale for the duty only exists in a case of actual insolvency. Now, here, of course, it's important that there is this common ground between us to some extent. Content of the duty is paramount importance to creditors in a case of actual insolvency. It's common ground, I think, that it's a subjective duty, fundamentally. Now, one point which may or may not be common ground, may or may not be relevant, is the question of whatever the trigger factor is it necessary that the directors actually know that that is the position? So if the trigger is actual insolvency, do they have to know that it's actually insolvent? Or is it enough that they either know or they ought to? The Court of Appeal's ruling on this, paragraph 220, page 217, was that it is sufficient if the directors ought to know of the trigger condition. Now, the outcome of this appeal won't turn on this point, and we submit the Court of Appeal is probably right on this. But the alternative position, of course, is that the directors will only be subject to the duty if they actually know that the trigger condition is satisfied. Now, that's really by way of preamble. So let's now focus on the question of whether the credit duty is triggered only by actual insolvency. And I'll first deal with the respondent's main argument. Now, in relation to that, there is first, before we get on to questions of principle and policy, there's the question of authority. And in relation to this, there is a wealth of authority identifying the trigger condition short of actual insolvency in Australia, New Zealand, and in this jurisdiction, including dicta in the Court of Appeal of the Supreme Court. Of course, the Court of Appeal decision in this case. Now, we've set out most of the relevant decisions. We've identified the important ones on this point. This is page 77 of our written case, just for note of footnote 16. That's just identifying the cases. Now, of course, we've actually summarized the cases at pages 57 to 63 and 66 to 70. So I don't want to go through all those. The important point is that there's no judicial opinion going the other way. Actually ruling that actual insolvency is required. It's true, as the Court of Appeal noted, that on the facts of many of the cases, the company was in fact actually insolvent. And so the expressions of judicial opinion suggesting that the trigger is less than actual insolvency were, we accept, in many but not all cases, obiter. But there isn't any judicial opinion going in the opposite direction. Now, in relation to the second point is in relation to the Act itself, 2006 Companies Act. We say section 172 subsection 3 leaves the door open as regards the content of the trigger. And the explanatory note 332 certainly contemplates the possibility, put it no higher than that, of a pre-actual insolvency trigger. And that's page 768. But we accept the meat of this in the context of that massive judicial opinion is really a question of principle, policy and practicality. So we've really got 3 points here. I mean, the first is, as a matter of policy and principle, actual insolvency would provide inadequate protection for creditors. Point one. Point two, it's not necessary to have a demanding trigger test of actual insolvency to achieve any countervailing policy objective. And third, actual insolvency would in fact be a relatively difficult test to apply in practice, despite appearing conceptually clear. Point made by the Court of Appeal, paragraph 218 of their judgment, page 217. So we'll deal with those 3 points in that order now, if I may. As regards the rationale for the application of the duty prior to actual insolvency, the premise, of course, here is that the duty does exist. And the question is, when's it triggered? The premise, therefore, is that it's at least triggered where there is actual insolvency. It arises at least in that context. Because, as we've submitted, that is because at that stage, the creditors have a greater stake as a body in the decision making on behalf of the company than the shareholders do. And the quasi-proprietary rationale in Kinsella explains that. The question here is, short of actual insolvency, do the creditors have a stake in the decision making of the company, which is sufficient not to overcome, supersede the interests of the shareholders, but just to be taken into account alongside the interests of the shareholders. So it's a different question. Creditors' interests have to be sufficient to justify modifying the duty, but not to the extent of taking priority over shareholders' interests. Now we accept that the so-called quasi-proprietary rationale in Kinsella doesn't, in terms, in full, apply pre-insolvency. But that doesn't mean it's not relevant to the pre-actual insolvency position. Because the Kinsella justification as a prospect, potentially a near and very probable prospect, justifies the lesser modification to the duty, which we say exists prior to actual insolvency.
Do I understand from what you just said, Mr. Thompson, that there's a point in time at which a duty arises to consider the interests of creditors, and there's a subsequent point in time, if the company is heading to insolvency, at which the duty mutates and becomes a duty to act in the best interest of the creditor?
Well, my lord, yes, subject to this slight adjustment. What we say is that there is the point in time, as my lord says, where the duty is to take account of creditors' interests alongside shareholders' interests. Then, on actual insolvency, the duty is to promote the success of the company for the benefit of creditors, giving them paramount importance over shareholders. So it's all through the medium of the corporate entity and promoting the success of the corporate entity as set out in section 172. But yes, my lord, what we're saying is that there comes a point where, on actual insolvency, creditor interests have to be given paramount importance, whereas before that, they're simply taken into account with shareholders.
So there are effectively two trigger points triggering duties which are different in the way that you've explained.
My lord, effectively, yes. And of course, if the court disagrees with the common ground that the parties have, broadly speaking, reached as regards the content of the duty, the court could hold that it is simply one duty to take account of creditors' interests, which applies from whatever the appropriate trigger point is, including in the event of actual insolvency, and leave it to the directors in situations, for example, of actual insolvency, to draw the conclusion that actually they should give paramount importance to creditors' interests. I mean, here, my lord, we have constantly a slight tension between the formulation of the duty and the question of exactly what, in practice, it's going to require of directors. I mentioned earlier the possibility of a sliding scale pre-insolvency. So the closer one gets to insolvency, the more directors might feel the need to prioritise creditors' interests, even if that is at the expense of shareholders. And I emphasise again, in making that point, I'm not for a moment suggesting that the duty should be formulated so that it includes such a sliding scale. That's an unnecessary and unhelpful complexity. All I'm simply saying is that it may well be that that's how directors actually, applying what is ultimately a subjective duty under the guidance provided by the courts and the Act, decide in fact to do. But it's a very fact-specific point.
I would be grateful to have some examples of how that works in practice. Suppose, to take a very, very simple example, a company simply has £1,000 in its bank account. And the creditor would say, if he knew about it, well, that's very good. I have a debt of £1,000 due in 6 months' time. So your duty, directors, is to put that money into a bank account to be held for that purpose. There are no other creditors, let us say. And the directors say, well, actually, no, we've got a duty to promote the success of the company. And we think that that money should be invested in some investment to promote the business of the company. And yes, we'll have the return, all goes well, to meet your debt. Now, how do the directors take a decision as to how to balance the interests of the creditors, the interests of the creditor and the interests of the shareholders in that sort of situation? That's a very simplistic example, of course.
Milady, yes, I've got a number of examples because I hope it's a useful way of trying to explore the application of the principle. I mean, my lady's example is a little bit like one that the Court of Appeal raised, I think in paragraph 199 of the judgment. I'm going to deal with that. I mean, I can deal with it now if it assists.
No, take it in the order, as long as we come back to this point, because I still am unsure how you say the directors will be able to balance the interests of creditors and members, particularly if there's any question of implying a sliding scale. I mean, they've got to find out about the solvency of the company. That may in itself be very difficult because they may need to put the auditors in and check all sorts of things, or take counsel's advice on the benefit of the likely benefit to be obtained from litigation, and then they might need to consider whether that's the correct advice, whether counsel's had the correct instructions. It's not an easy exercise to know necessarily when a company is solvent or insolvent.
But, milady, if my lady doesn't mind, I will deal with it in order because I'm going to come to.
Of course, I want you to deal with it when it's logical.
Thank you, milady. But just to be clear, we are not for a moment going to be suggesting that life is easy. What we are going to be saying is that the difficulties that arise in this situation, that is pre-actual insolvency in particular, are inherent in the situation. And the application of the creditor duty is simply requiring directors to do what they should do. And any difficulties created are simply inherent in what is necessarily, with a company threatened with insolvency, a difficult situation. But I will deal with that, my lady, I assure you.
But my lady's question really raises a more fundamental issue, which we may have to think about, which is that at the end of the day, limited liability companies are vehicles for enterprise, and the word limited at the end of a company's name is a red flag to creditors, that they deal with such a company at their own risk. And there's obviously an issue as to the extent to which the duty that you're arguing for in protecting the creditors from risk also jeopardizes the enterprise, which is the whole rationale of limited liability companies.
My lord, indeed, and we absolutely take that on board. And when I was referring in my little mini roadmap just now to countervailing policy considerations, that's essentially part of what I'm talking about. So I recognise the need to say not just creditor protection requires this, but also there is no more powerful countervailing consideration, such as the one my lord mentions, which counteracts it and knocks it out. So I'm absolutely going to deal with that, Lord, yes. Now, dealing with the question of whether actual insolvency is required or something less. As regards the question of whether creditors' interests are sufficiently affected, I would respectfully suggest that much can be demonstrated by reasonably simple examples. Before one gets to the perhaps more difficult examples involving countervailing considerations. The respondents' case here is quite important to bear in mind, because the respondents are saying at this stage in their argument, well, it's actual insolvency or nothing. And so it follows that what they're suggesting is that one has a very stark disjuncture as one moves from something short of actual insolvency into actual insolvency. Because on their case, on actual insolvency, if they're wrong in trying to knock out the creditor's duty altogether, they accept that creditor's interests become paramount. So you do have a very sharp shift on the respondent's case when that line is crossed into actual insolvency, between before that creditor's interests having no place at all in the director's deliberations, or at the very least shareholders' interests being absolutely paramount and exclusive. And then, after that point is crossed on the respondent's case, there is a complete 180-degree shift with the creditor's interest becoming paramount. And we do say that's inappropriate because it doesn't reflect the actual reality of the interest and the weight of the interests of those two bodies, the creditors and the shareholders. So take, for example, a company, to keep it very, very simple, which just is regarded as having a very high probability of going into actual insolvency in the foreseeable future. Say an 80%, 75% chance, it doesn't really matter. The point is, at that stage, on the respondent's case, the directors don't need to consider creditors at all. But quite clearly at that point, if the directors take a decision which involves a loss to the company, so assets are lost, who's affected? Well, there's an 80% chance, in my example, that actually it's the creditors ultimately who are affected. Their interests are affected, and the shareholders' interests aren't really affected at all. And so, obviously, you can move the percentages around, but the point is, prior to actual insolvency, because there is a probability of insolvency or a real risk of insolvency, the creditors' interests are already engaged, and it is not an enterprise anymore that is being pursued entirely for the benefit of members. It's being pursued, we say in practice, and this is what the law should recognise, both for the benefit of members and creditors. And the danger again is that if the respondents are right, then in this situation where one can see it's really quite probable that the company is going to go into actual insolvency in the foreseeable future, then if directors are only required to consider shareholder interests, then there is a very real danger of bet the farm type strategies, because those are the strategies that are going to be required if the directors are trying to salvage something for the members. Whereas if what they're required to do is consider creditors as well, that will temper that possibility. Now, we accept, of course, that the creditors' interest and the shareholders' interest are different. They're different natures. Of course, that's the case. We're only looking at the group position. But one respect in which they are different, which is actually relevant to the question of whether creditors do need protection, is this. Shareholders at all stages, at least prior to the intervention of administration or liquidation, will control the composition of the board. They will ultimately, in reality, control the affairs of the company. Whereas creditors at all stages up until that point are shut out of that. So this is another reason why, in the position short of actual insolvency, creditors' interests deserve protection. And the law recognises the importance of creditors' collective interests, quite obviously and uncontroversially, through the provision for the liquidation and administration regimes. And clearly, that isn't a complete protection, and it's a relatively drastic remedy, which one would not want to have as the only means protecting creditors' interests, because it's so drastic. But it is a recognition of the importance of the need for protection of the creditors' interests collectively. Now, of course, those remedies are only available to creditors in limited circumstances, in relation to liquidation if the company is insolvent, and in relation to administration if it is at least more likely than not that it will become insolvent. If I can just give the court the references to the relevant statutory provisions in Schedule B1 to the Insolvency Act in the bundle, they are 794, 800 and 802. There's also the Colt Telecom case in the bundle. The relevant reference is 2744, which establishes that administration is something that can be applied for to the court or initiated out of court, but only when the company is either insolvent or more likely than not to become insolvent. Now, not only does that show that, as I've just indicated, creditors' interests are regarded by Parliament as worthy of protection collectively, but also it shows that that may well be required even through the drastic step of administration prior to actual insolvency. So where the insolvency is only likely, more likely than not, which of course is effectively the Court of Appeal's test in relation to the creditor duty. I noticed the time. That is as convenient a point to stop as any, so I probably should, if that's convenient to the court.
In that event, we'll adjourn just now and resume at 2 o'clock.